Okay, next case, 22-21, State of Florida versus Eduardo Arturo Torres. Counsel, whenever you're ready, go ahead.
Thank you, Your Honor.
You're Mr. Pallas, right?
Yes, sir.
Okay, thank you.
I understand we had some musical chairs earlier. May it please the court. My name is Richard Pallas. I represent the state of Florida. The state is appealing the trial court's suppression of evidence, specifically breath test results, in the absence of a mutual aid agreement. It's the state's position here that this was error because this was a continuing investigation and thus didn't fall under the color of office.
Let me ask you about a mutual aid agreement. If I'm reading 23.121, the policy and purpose of a mutual aid agreement says because of the existing and continuing possibility of the occurrence of natural or man-made disasters or emergencies and other major law enforcement problems, including those that cross jurisdictional lines, then it goes on that you can have a mutual aid agreement. I mean, why would a mutual aid agreement be of assistance in the context of a misdemeanor DUI investigation?
I mean, well, yes, Your Honor, I can see how this necessarily wouldn't play into here, and I want to say that's part of our position why this mutual aid agreement isn't necessary in the first place.
Let me follow through. I mean, what if everybody just said, okay, we write an opinion here today, and the case is affirmed because there's no mutual aid agreement. Why doesn't all counties just get with all the municipalities within their county and say, hey, we're going to have a mutual aid agreement that says we're all going to help each other about any kind of criminal case whatsoever, so we don't have any kind of things suppressed because of this type of jurisdictional dispute? I mean, that would seem to be inconsistent with what this, I mean, the title of the statute is policy and purpose of one of these agreements. I mean, if we had one of those on a misdemeanor case, then basically we're saying, it would seem to me, tell me where I'm wrong, or Mr. Hyman can tell me where I'm wrong when it's his turn, it's basically saying everybody can be a law enforcement officer wherever they want within the county. I'll just use the county for the purpose of this question.
Oh, yes, Your Honor, and I can see that. Based on the letter of that statute and obviously their express intent, as that's the policy section.
We all know that we got to follow the intent of the legislature around here. You don't want to go cross hairs with that.
That's the pole star of statutory interpretation, Your Honor.
Yeah, that's beating everybody's head like a drum here.
Of course, here we're of course not relying as much on statutory intent for these.
But I'm curious. I mean, I know that you all had an earlier. I know the PCA in the other case is not precedential value, but. You know, you start off, and that was certainly the discussion that the trial judge said, well, why don't you just put the mutual aid agreement in? And I'm just curious as to why a mutual aid agreement in a misdemeanor DUI case, why that would be something that would fall under the policy and purpose of this specific statute.
No, certainly, Your Honor. I can see how it doesn't seem like, based on the text that you read here, that's within that purpose. And
I mean, I'm following down the road. And the next argument, when you do put that in, and the next time you have a DUI, and Mr. Hyman, I think, would fairly get up and say, well, yeah, that's not a very good mutual aid agreement because, hey, it's only for natural or man-made disasters or emergencies. And I don't know that, I mean, certainly a DUI case can cause havoc and certainly cause great harm and distress to people, but I don't know equates to a hurricane or a flood or something like that. That's
No, certainly, Your Honor. And then that, of course, goes to our point that the mutual aid agreement isn't necessary in the first place. I mean, it seems to me that the trial courts below in the Ninth Circuit, both pursuant to the previous appeal that we had that was per curiam affirmed, as well as this appeal here,
Is this a recent phenomenon in the Ninth Circuit? Because I've read a case from one Florida Law Week sup in 1993 with somebody named Judge Golden as the judge, and State versus Raymond Gromlowitz when somebody named Mr. Stuart Hyman as the attorney for the defendant. Judge Golden didn't think much of this argument that apparently has become successful in the Ninth Circuit. I guess Mr. Golden, or Mr. Hyman's argument has mellowed over the years and become more effective.
I mean, I've certainly seen,
At least in the Ninth Circuit, and certainly at the 5th DCA at the last case.
That's correct, Your Honor. I mean, overall, I believe at least 3 to 5 cases were mentioned at that time where relief was granted under this theory for the motion to suppress. In our case, it seems like it's the 4th District's decision in Matos that might have triggered at least.
Well, I mean, isn't Matos distinguishable right from the outset? Because, I mean, and I'll give the officer the benefit of the doubt. Apparently, one side of the road was one city, and the other side of the road was the other city, and the defendant was on the north side, and the officer was I mean, he was basically he was a citizen making an arrest, and then that naturally follows that if he's making a citizen's arrest for a DUI of a breach of a peace, which he's permitted to do under common law, but at that point, he doesn't then have the indicia of being a law enforcement officer and to order a breath test, because only law enforcement officers can order that. So, I mean, Matos certainly is talking in the context of a DUI, but I think from the get-go, that's a distinguishable case.
Absolutely, Your Honor, and that was the state's point in its briefs, that Matos doesn't control us on these facts here and the trial court shouldn't have been controlled by it below. I
mean, even in Griffiths, I know that was the first Judge Orfinger wrote the 5th DCA case back in '87, where the Titusville police officer went to Cocoa to do a search of the defendant's house, and the warrant said the Brevard County Sheriff and Titusville can go search, and I think Judge Orfinger's opinion saying, I don't know why the Brevard County Sheriff didn't just go there and serve the warrant, which would make perfect sense too. But that being said, I mean, there wasn't, if I read that opinion, there wasn't an arrest. I mean, that to me, that's, you're executing on a search warrant because you want to get evidence to then charge the person. And so in essence, that officer there was going outside his jurisdiction to get evidence that would lead to arrest, whereas here, the evidence was in Winter Park. I mean, the probable cause to stop the guy, I mean, I know Mr. Hyman wrote other motions, but what we're talking about today, assuming that the probable cause were to stop him in Winter Park, the DUI occurred in Winter Park, the field sobriety tests were done in Winter Park, so I mean, the evidence, and he was arrested in Winter Park. So I mean, right?
That is correct, Your Honor.
Okay, so I mean, I don't know that Griffiths is really all that on point in the context of what the legal issue here is of your officer gathering evidence at I guess the Orange County Sheriff's, 33rd Street or wherever they took him to?
Yes, the Orange County Sheriff's Office's DUI center outside of Winter Park in Orlando. Right. But yes, Your Honor, I do agree. Judge Melvin Orfinger's opinion in Griffiths, specifically talking about that all we have in the facts of that case is it was based on sworn information that stolen property was at the defendant's home in Cocoa. The Judge Orfinger took problem with the fact that Cocoa police officers were not mentioned in the text of the actual warrant, even though they were present.
Well, because they're the ones who have to execute the warrant if it's in their jurisdiction.
Absolutely, Your Honor.
You had a Titusville municipal officer executing a warrant in Cocoa, which he had no authority to do, certainly pre-arrest.
That is correct, Your Honor. And obviously in those situations, I mean, we afford such higher standards of Fourth Amendment protections to the home in the first place. I mean, State ex rel Wilson versus Quigg, which was, I believe, the 1944 decision that was cited in the Griffiths opinion, that only refers to search warrants in that opinion and its precedents in both, I believe, the cases.
Let me ask you this. Let's turn back to the facts of your case, and let me throw a hypothetical in, and hopefully it doesn't cause the disarray that my hypotheticals on Tuesday were causing with other panels. But all right, let's say that your officer took the fellow, Mr. Torres, over to Orange County and said, hey, you know, here's the guy who's going to operate the breath test. Will you give the breath test? or will you submit to the breath test? Even though he politely consents to it under the statute. I get on it, but forget, past that for a second. If Mr. Torres had said, no, I'm not going to do it, and then that evidence could be presented at trial, would there be something that would cause the officer to not be able to testify that I heard Mr. Torres say that he would not submit to the breath test? I mean, he's not extracting something from him. He's listening, it's observable thing that anybody else could have heard him say. So would he be able to have testified, or would the trial judge have erred in, I mean, I know you think he erred already, but under my hypothetical, would the trial judge have erred in suppressing evidence about him refusing to take the test?
Just so I can clarify, Your Honor, you're saying that in this event that the defendant had declined under the implied consent, and the trial court said, well, I will not allow that refusal in.
Mr. Hyman says you were trying to extract evidence, Mr. Winter Park officer, you're trying to extract evidence from this defendant in Orange County, not in Winter Park, therefore that is suppression because you are outside jurisdiction, you're using the color of your office to get this, and you can't do that. But I mean, it seems color of the office, or whatever, how they phrase that, refers to you're getting something as a law enforcement officer that a private citizen couldn't get. I mean, the private citizen would hear the guy say no. He's not extracting breath test.
Absolutely, Your Honor.
So would that have been admissible? Would there be less reasons, in your view, to suppress that kind of evidence?
I mean, certainly, it states in the implied consent that refusal will be used as evidence against you at the very...
It's a warrantless search. I mean, basically, under Birchfield, it's a warrantless search. You consent to the breath. I don't need a warrant, which suggests to me there's not, I mean, unless I'm wrong, I haven't thought this deeply through, but so it's not really a Fourth Amendment issue, is it?
Well,
seems like it should be, but I mean, I don't know. But I mean, if it's a permissible warrantless search. Well,
certainly it's a warrantless search. I mean, we have Supreme Court precedent talking about these breath tests being known as searches, certain times they're considered searches. But here, at least under this, as interpreted under this particular doctrine, it's a Fourth Amendment doctrine. I mean, to me, it's almost more of a statutory violation here. The defendant's argument here boils down to, you read me the implied consent statute outside of Winter Park, that's no good. You read this statute to me, though, within Winter Park before you take me over, and I say, yes, I'll do the implied consent.
That's going to be my next question, actually, is saying if your officer had said, okay, I'm starting to get the lay of the land here, I better ask for the test in Winter Park, and the defendant answers in Winter Park, yes, I will take the test, for whatever reason. Maybe he doesn't think he's going to turn out, he don't want to lose his license, he thinks he's going to pass the test, so sure, I'll take the test, I'm not impaired, sure, you want me to take the test, pal? I'll take your test. So if the consent is given in Winter Park, but you actually, let's say, use my hypothetical, the Orange County breathalyzer machine is across this Winter Park, whatever the boundary is, I don't know where, ask these guys in Orlando. I walk across Winter Park and I'm in Orange County, and there's the handy-dandy breathalyzer machine, and so I'm 12 feet outside of Winter Park, but the consent was given in Winter Park. Does that become suppressible too? Is that a violation?
I mean, to me, it shouldn't matter where this is read, of course, based on our argument here. But under the defendant's argument, if it was read there in Winter Park, it's not suppressible then. But to us, that's just not how this issue should be framed. I mean, essentially, we have a case where the trial court ruled we had probable cause that this man was DUI because the man almost ran into him. We did the field sobriety exercises. We noticed the smell of alcohol and we saw his glassy eyes. We had a lawful arrest. We were allowed to seize his person, but under the defendant's interpretation of the implied consent statute, if we can't read that, we're allowed to seize his person, but we're not allowed to seize his breath. And of course, we have plenty of case law saying how non-evasive these breath tests are compared to blood tests, and obviously compared to allowing a search of a residence pursuant to a search warrant, Your Honor.
Well, I mean, the exception of the color, what is the color of the office? The exception is a municipal law enforcement officer can exercise their law enforcement powers only within the territorial limits of their municipality, but they can do it outside their municipality if the subject matter of the investigation originates inside the city limits.
Yes, Your Honor.
Okay, so it would seem the subject matter is this person a DUI, has committed the DUI, offensive DUI. occurred in Winter Park. There seems to be no dispute that, assuming he's a DUI, it happened in Winter Park. So what is it, how is that then not within the exception to the rule that Mr. Hyman's relied on, that, okay, I'm just continuing my investigation. It's contemporaneous. I'm continuing my investigation. I can go outside. I got to drive across the Winter Park boundary line and go to the breathalyzer machine, but it's part of my continuing investigation of the same subject matter. I'm trying to understand, well, how does this not apply to that? What would be this? Is it because I'm getting breath? That's what causes it to be outside of?
Your Honor, that's my sentiment exactly. It's the state's position that continuing...
Well, tell me why you play the devil's advocate to my question. Why would that be properly suppressible according to Mr. Hyman, but more importantly, the trial judge below thought that was properly suppressible?
The only way that I can see this being not suppressible is that the trial judge rejected that particular thought that we were allowed to continue our jurisdiction and stated there was no mutual aid agreement.
I mean, I get, the trial judge kind of said, well, everybody's kind of ruling this way, and you don't have a mutual aid agreement. If you guys would just do that, you'd make my life easier, and which you guys who are trial lawyers should understand. If you can make the trial judge's job easier to rule in your favor, it would be a typically wise thing that you ought to think that through before you actually go to the courtroom. But that being said, having been a trial judge for a long time, that's wishful thinking for a lot of us that you'd all actually do that. But that being said, all right, so. There didn't seem to be a whole lot of detailed analysis from the trial judge. It was kind of, well, that's just kind of how this is playing out in Orange County, and if only you had the mutual aid agreement. In fact, I think he actually said if you'd had the mutual aid agreement, you'd win. I deny the motion, not you, but your side.
Oh, certainly. Obviously, the mutual aid agreement was brought up. The prosecutor below asked that if evidence would be held open until...
Y'all put that in evidence now, for better or worse now? Do you do that?
I mean, regardless, of course, had the trial judge relied on this particular exception, you don't need it in the first place. But once it seemed like he was not going to rely on that, of course, the prosecutor is going to try to get it in for additional evidence.
Well, it seemed like they ought to have had it, since that's the way the direction has been going in Orange County, that would be something you all carry with you in your file, for lack of a better term. You've got 352 if you want to keep going, or if you want to I'll rebuttal.
Just to, wrap up just for a moment, it's our sentiments exactly that this continuing investigation exception is what should go on. It's so simple that these law enforcement officers are transporting them just basically a city over within the same county. And of course, we rely on also the additional case law we found from out-of-state cases from Arkansas Supreme Court, as well as North Carolina Supreme Court and Rhode Island Supreme Court. The state asked that you reverse, but we will reserve the rest of our time for rebuttal, Your Honors.
Fair enough. All right, you got 314 left.
May it please the court, Stuart Hyman on behalf of Mr. Torres.
Well, let me start with where I started with your opponent here.
Okay.
Why would a mutual aid agreement be applicable here? I mean, that seemed to be what the trial judge said. Hey, if you had that, I would have denied your motion. I think that.
Your Honor, I agree that a mutual aid agreement I never have believed would resolve this situation.
It would seem like the county would just have a mutual aid agreement with everybody, all the municipalities, and say, hey,
they'd all be under one sheriff.
It'd be a free-for-all. You'd be one jurisdiction.
Yeah, it'll be everybody under one sheriff, and whatever happens. And
That seems what that is too. Yeah, okay.
I don't think the mutual aid agreement is the issue here.
Okay. Well, I appreciate your candor. I won't beat you up on the head on that.
If that's the way they want to attempt to circumvent the problem and legally it's okay.
Of course, that's what the trial judge keeps telling them, but that being said.
Well, I think what the trial judge is telling them, and I appreciate going back to 1993, and that Gromolowicz case was memory lane for me, but what's happened since Gromolowicz is the 4th District Court of Appeal decided Sills, and the 4th District Court of Appeal decided Matos.
I mean, those cases are different. In Sills, they were investigating an unrelated second case, even though it was the defendant turning them on to it. It was unrelated to the first case, so the subject matter did not occur within the police officer's jurisdiction. And in Matos, as you know already, you're probably could recite it in your sleep, but, I mean, he was literally on the wrong side of the street from his jurisdiction when he began his investigation. Here, you know, I look at the Goodman case, I look at State versus Price, and you even look at the Nunn versus State case, and if the subject matter of the investigation began within the municipal officer's jurisdiction, or in none, even if it didn't, but in good faith the officer thought it did, the investigation could continue outside the jurisdiction. And I'm just having trouble, and I'm real sensitive. I'm picking up that Judge Lambert's having a little trouble too with why this doesn't fit into the continuing investigation exception.
Because the Fourth District Court of Appeal in Sills addressed that. That was the argument the state made in Sills. That was the exact argument they made.
Those are unrelated crimes. He got busted for one thing properly, and then he goes, hey, maybe I can cut a deal if I tell you about this other drugs I got outside the jurisdiction.
And I agree. Factually, we're dealing with a different situation, but legally, we're not.
Well, I mean, the 4th DCA basically, while the conceptual idea to investigate came to the officers within their own jurisdiction, the subject matter, which is what the exception is, the defendant's possession of the other substance was never in their jurisdiction. So at that point, the officer's investigating a second crime that didn't occur in his municipality in another jurisdiction of which he has no authority to do. That to me becomes problematic and why the defendant wins in that case.
But Sills went further, because if you go down the opinion, after they're talking about that, they get into the next section of it, and they said that even if it could be said that in this case, the subject matter of the investigation did originate within the officer's jurisdiction, the line of cases relied upon by the state is expressly noted in State versus Phoenix with the following caveat. Nonetheless, the principal espoused, and these are the exact cases that we're talking about, the continuing ones.
And I'll follow up with you on that our Supreme Court makes extremely clear that dicta is not very persuasive. And this seems to be dicta that, I mean, I agree, I'm looking right at what you're reading, so I agree with you reading it correctly and I understand it. But I mean, they're basically saying, you know, okay, we've held, but you know, alternatively, this, what you're about to say.
Well, they followed it back up again in Matos because they cited Sills and Matos.
But I mean, it's the same if we wrote an opinion and we started opining about other scenarios. That really wouldn't be the holding that we would have given here in this case, assuming write an opinion in this case.
But Matos was not another scenario. In fact, Matos, and I grant you that in Matos, the original arrest was out of the jurisdiction. I understand that.
That's basically the tail that wags the dog, isn't it?
Well, not really, because the finding was that there was still a lawful arrest because it was a breach of peace, citizen's arrest.
I agree. It's a lawful citizen's arrest.
The next question, though, became, after the lawful arrest, regardless of whether it was out of a jurisdiction or in a jurisdiction, can the officer use, and Matos is the first case that I've been able to find in the state that found that the request for the breath test is use of color of office. But at that time, though, he's basically a private citizen, and the statute doesn't allow privates. I mean, you agree, the statute doesn't allow private citizens to ask for breath tests in the course of a citizen's arrest. I agree, but even when Officer Campbell in this case goes out of his jurisdiction, he becomes a private citizen. That's where Griffiths even said that once that officer went out of his jurisdiction, he is a municipal police officer located outside of his jurisdiction. He's nothing more than a private citizen.
So do you think that the continuing investigation exception is a fiction that doesn't exist?
No, I don't believe it's a fiction. I believe that municipal police officers can go out of their jurisdiction and continue investigation.
Well, give me an example of them doing that.
But what they can't do is they can't use the color of their office to ferret out evidence that's not otherwise observable or being voluntarily provided.
So they can't investigate as police officers?
And that's, well, no, they can, but they have to get someone with authority to do that.
Well, let me follow up then the question, the hypothetical I gave to Mr. Pallas. So let's go back to our case. So he takes your fella to Orange County and he asks for the breathalyzer test, and your client consents, and that's where you're saying that's bad, you were able to convince the trial. What if your client says, no, I'm not going to consent to that, I will say no, I understand, I will reject that, now he's not ferreting out, I mean, he's now just heard statements, or is that a ferreting out that is not permissible?
That's a ferreting out, and here's what we need to remember here, that DUI can be proved by driving under the influence of alcoholic state, your normal faculties are impaired. But there's a separate provision that they go under for unlawful breath alcohol level.
Okay.
And also, that crime doesn't get created in Winter Park, it gets...
What if they don't charge him with that?
Right.
What do they just charge him straight DUI?
They can't charge him in Winter Park because there's no breath test at that point.
Okay, so they don't charge him with that, but they're accumulating evidence to support their DUI charge of which your client has been arrested in Winter Park for committing the crime in Winter Park.
But then you were asking about the refusal.
Right.
It's now a crime to have a second refusal. In other words, if you ask somebody to take a breath test and they have previously refused to take a breath test, you've now created a crime outside of the jurisdiction.
All right, well,
by asking
let me give you
to
my
take the breath
hypothetical.
test.
It's your client's first refusal. All right, so it's his first refusal. So now what? So he's not committing a crime by the refusal, fortuitously or unfortuitously, if that's even a word for your client. But I mean, let's say it's, all jokes, kidding. So I mean, I know it's a serious stuff. All right, so he's refused, and he's chose to refuse. He's not committed a crime, but now that is evidence that can be used under the statute as, proof of perhaps a DUI.
Yeah, under the statute, but the statute also says that it has to be made at the request of a law enforcement officer. Mm-hmm. Florida Statute 316.1932.
1932 sub 1, right.
See, and that's where I saw the similarity, and I know you were bringing up that you didn't think that Griffiths applied. Where I thought that Griffiths did apply is because in Griffiths, there was also a statute that said it had to be a law enforcement officer.
But he wasn't arrested. There wasn't an investigation. This crime is occurring. He's been arrested, and he's investigating the crime, the continuing jurisdiction thing. So, I mean, Griffiths, he's going outside of his jurisdiction to execute a search warrant, which he's not entitled to execute in COCO, to gather evidence to charge him. So, to me, Griffiths is a lot different.
The holding in Griffiths, if I'm reading it correctly, the holding in Griffiths was that because there was a statutory violation, that made the fact that he was out of his jurisdiction and violating the statute something that a municipal police officer couldn't do because the statute contemplated that it would be a law enforcement officer with power to act who was executing that search warrant. In 316.193, too, by analogy, it has to be a law enforcement officer who has the power to act that requests that breath test. For instance, let's go back to the first refusal. If I am the defendant, I guess, and the police officer comes to me out of his jurisdiction, and everybody's assumed to know the law, and so if my client knows that only a law enforcement officer can request a breath test, and he knows, maybe he's an attorney who's the defendant in the case, and he knows that this police officer is not in his jurisdiction, and therefore under the case law, he's nothing more than a private citizen because he's a municipal police officer located out. I have a right to not take the breath test because you're not a law enforcement officer at this point requesting me to submit to a breath test. Mm-hmm. I mean, we have to figure there have been some defendants that have been lawyers. And they...
Possibility, isn't it?
And the law... I mean, if I'm a lawyer and I'm analyzing it and I'm saying, okay, all this case law says when a municipal police officer goes out of his jurisdiction, he's nothing more than a private citizen. You're a municipal police officer located outside of your jurisdiction. You're a private citizen. You're now trying to create another crime, that being either an unlawful breath alcohol level or potentially even a second refusal.
Let me go back again to the continuing investigation thing. If I understood you correctly, the municipal officer who goes outside of the city limits basically has to phone a friend, another police officer, deputy sheriff, or whatever, who is legally authorized to conduct that investigation within the second jurisdiction. That's what you're saying?
Potentially.
No, yes or no? I mean, again, we've got here an officer...
The way to correct the problem, honestly, is what used to be when I was first starting all this.
Everybody's a deputy of everything else,
No,
right?
no, 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 no. All these municipalities had their own breath testing machines. So they would just take them to the Winter Park Police Department, and they would submit them to a breath test.
Okay, but I mean, let's, where I'm from, Marion County, you got a small, city of Dunellen, 1,000 people. They're not gonna have a breath test in the city of, a breathalyzer machine in the city.
Claremont does. Claremont does.
Clearmont's 10 times the size of Dunellen.
I don't know, I'm not from that.
Well, I'm telling you, or Bellevue.
Carabelle, how about Carabelle?
No, I'm just saying, I mean, that's the pragmatic.
What I'm saying, I guess, and this has been my argument on this all along, is that I don't create these legal principles. The case law creates these legal principles.
Right.
And the legal principles that I see being created, following it all the way up through Matos, is that when a municipal police officer goes out of their jurisdiction, they're a private citizen, and they cannot use the color of their office. In fact, even in the Sills case, when we were talking about the continuing jurisdiction, one of the things, because they were dealing with the state's argument, which is the same argument, and it said, thus these cases are not, as argued by the state, both below and here, a separate and distinct issue from the under color of office doctrine. Rather, they are subject to that doctrine, not immune from it.
Let me ask you, Mr. Pallas seems to think, or he postulates that if we modify the facts here, if the Winter Park police officer says, okay, you've failed your field sobriety test, I'm putting you under arrest, and if he at that point in Winter Park had asked your client, will you submit to a breath test under the implied consent law, and reads it to him, and haven't tipped his hand yet as to whether they actually have a machine in Winter Park or not, and your client said yes, let's assume it was freely and voluntarily done by your client because he said, I don't want to lose my license for 18 months or whatever amount of time it is. I don't want to lose my license. And then the officer says, well, thank you very much. Please get in the squad car. We're driving across the street into unincorporated Orange County to do the breath test. It's a 2-minute ride. Our machine's broken. Would that still be problematic to you because he's crossed the border of Winter Park to have the test administered?
In my opinion, what would be problematic, just like it was problematic in Griffiths, because that involved a search, there's a search of that person. Granted, you don't have to have a warrant to do the search for breath, but it is still considered under...
You impliedly consent to giving that. You consent to that as a part of your privilege of driving.
Well, under this court's decision in, I think it was Lyles and maybe Dobrin, or I may have the case wrong, I'm sorry, but the...
You're not going to tell me I wrote that, did you?
I'm not sure.
I hope not. I didn't like that.
Doosan. And those were cases where blood required a search warrant. But of course, it came up in those cases about whether or not for breath there needed to be a search. And the case law from Birchfield, even from the U.S. Supreme Court, is that it is a search. Yeah. So you are, even though it's warrantless, it's still a search being conducted by the officer out of his jurisdiction by obtaining that breath sample.
So even if it was a consented to search?
Yeah. Well,
so basically in response to Mr.
Consented to search, that's a little different. I mean, express voluntary consent, yeah, you can have my breath, probably that's okay. Mm-hmm. But if you're going to use an implied consent warning by saying, look, if you don't give me your breath, I'm going to take your driver's license, that's probably...
Well, I know, but I think somebody wrote, I don't know if it was me, but somebody wrote, says, well, if you don't tell them that's what's going to happen, you just ask them, they give it to you, then that becomes problematic too, because you haven't told them the ramifications.
Unfortunately, when it comes to DUI cases, or fortunately, however it is, they're more complicated sometimes than homicide cases I've been involved in. There's so many laws and so many statutes and so much case law that when it starts trying to be interrelated with one another, it was where the problem is. But truthfully, in the past, there are agencies that have their own breath test machines, and they give them a breath test. The breath test is only a $5,000 machine. The city of Winter Park,
they got
probably
money.
one of the jurisdictions that could swing that.
Yeah, I mean, we wouldn't, obviously, if they had the machine there was working, it wouldn't make sense for them to drive otherwise, and we wouldn't be having this discussion.
If it wasn't working that night, you could theoretically, I guess, get a law enforcement officer from Orange County or another municipality to do the breath test. Maybe get the consent in Winter Park, and then take them to a place where law enforcement does
So in
it.
response to what Mr. Palace's belief, asking your client to consent to the breath test in Winter Park itself, that wouldn't have solved the issue. It's because once he went into the unincorporated Orange County, or wherever it is, outside of Winter Park, and got the breath test, that's end of discussion, that you are acting outside your authority as the officer, and therefore it must be suppressed.
And I know that this is all, you know, it could be semantics or whatever, but it's not really semantics, because it's all based on established law. And I cited the Sobrino case in the brief because, at least back then, when that District Court of Appeal was deciding jurisdiction issues, they thought it was pretty serious, the powers wielded by police officers. Because you create a slippery slope. If you allow this, then what prevents the officer from doing some kind of search of somebody's pockets down at the jail? Or
And I mean, it's not an automatic, I mean, the suppression is not automatic. I mean, it's,
I agree.
but that's not been argued below. I mean, we had a case in a DUI a few years ago, a double homicide, where they didn't follow the correct statute to get the medical records from the hospital, and I wrote that.
it was at Dinkins.
Yeah, and I wrote that and said, well, you know,
Yeah, the,
probably didn't care for that case,
I
did you?
just- my philosophy has always been, in 40 years of doing this, I guess, at this point, I hate to say that, but, you know, I look at what the law says and what the case law says and what the legal principles are, and I try not to draw exceptions on what the facts are of a particular case unless it's a fact-specific kind of situation that makes a difference to that legal principle. But I don't see where these legal principles that have been established by the Knight case, by the First District Court of Appeal has accepted this, the Griffiths case accepted this from this court. I don't see where these legal principles can be compromised just because this is the request for a breath test versus something else where the officer's seeking evidence of a crime. And sometimes in a case, like we're dealing with a misdemeanor case here, but sometimes it can become a lot more serious if you're dealing with a DUI manslaughter case or a more serious kind of vehicular homicide case where they're trying to gather evidence outside of their jurisdiction as well.
Let me ask you this, Mr. Hyman, if I can. If we're going to strictly construe 316-1932, and it says the test has to be requested by a law enforcement officer, clearly Officer Kimball is a law enforcement officer, at what point are you saying he loses that role, he loses that capacity?
According to Griffiths and Phoenix, when he goes out of his municipal police officer, once he goes out of his jurisdiction, he becomes a private citizen.
That's not absolute, is it?
No. For purposes of using the color of his office to ferret out evidence. In other words, he can leave, let's say he's transporting somebody to the jail, he has to turn them into the jail. He's not using the color of his office there to ferret out evidence that's not otherwise observable. He also could drive along with the guy and be talking to him, and the guy might be making all kinds of admissions in the back of the police car as he's driving him there. Unless the officer is specifically seeking those types of statements from him while out of his jurisdiction and trying to obtain information that wouldn't normally be available to him.
Well, let me ask this. So, all right, so I arrest you in Winter Park, and for a DUI, I ask you in Winter Park, will you do the breath test? He says, no, I'm not. And so the officer says, all right, fair enough. I'm taking you down to the Orange County jail. And as he gets to the jail, he says, you know, I forgot to search this guy incident to the arrest. So I'm at the Orange County jail, and I said, well, before I turn him over to the Orange County jail people, I'm going to search this guy. And he searches the guy, and the guy's, you know, got weapons and drugs and all this other stuff. Is that all suppressible now? Is a search incident to arrest because it happened outside of Winter Park?
You know, initially, if you apply these principles strictly, it might be, but I'm not going to sit here and say that I've given that a whole lot of thought on that kind of situation.
I just thought about it earlier today, so I'll give you that.
I mean, he is using the color of his office.
I mean, but that's the issue that was struck. I mean, clearly you can do a search incident. You ought to do a search incident arrest to make sure everybody's safe and.
But you could also have the corrections people down there.
Well, you could have, but you know.
I mean, there's other ways to accomplish these things.
Well, yeah, I mean, he could have just had the Orange County deputy do this, but yeah, but,
Again, I just have to go back to, these are the principles, and Matos is the first case, and I know because, I agree that it was a out-of-jurisdiction arrest, but the actual request for a breath test took place out of that officer's jurisdiction in another location, a breath testing facility, and they specifically said that that was using the color of office. The actual request for the breath test was use of color of office. So we know that requesting a breath test, at least under that precedent, is use of color of office.
okay. All right, I'll let you go 2 minutes past, so I assume you want us to affirm.
I would ask that, thank you.
There you go. Thank you, counsel. All right, Mr. Pallas, you have 3 minutes and 14 seconds. Mr. Hyman says, that's not what I meant, just because you asked for the breathalyzer in Winter Park, that still doesn't solve it. So there, you got your answer on that one there. How about that?
Well, thank
Or
you.
according to him. Well, anyway, that's our answer on it.
Well, may it please the court, Your Honor, obviously, in addition to that, I have just about 2.5 points to rebuttal. But on that, I'm not sure then what the reading of implied consent.
Stop on that third point. You're going to stop right there halfway through? All right,
Just,
go ahead.
I'll end mid-sentence, Your Honor.
There you go. Go ahead.
But necessarily, if reading it there then triggers this, then I don't understand what this statutory violation is. If this goes in with Griffiths, I mean, sections 933 and 07 and 08, those are completely different statutes from the implied consent statute 316, 1932. I mean, in the two statutes at the center of Griffiths, we're talking search warrants. Any law enforcement officer, or any police officer, I believe is how it was stated in that. And because this was a search warrant for a home, a residence, in Griffiths, they construed that strictly. And in that case, they would say any officer with the power to act. We are not dealing with the search of a home. We're not dealing with a warrant. We're dealing with a very, basically, a breath test, which is not that invasive of a seizure of this person's person, which we have already seized due to lawful arrest. And I believe Griffiths says nothing about implied consent. So I don't believe we should read into that. And going into my next point,
Before you get there, you make an argument somewhere in your brief that even if there was a violation in this case, it's de minimis, basically, and suppression is too harsh a remedy.
That's correct, Your Honor. That was a point in our briefs citing to, I believe, case law out of the 11th Circuit Federal Court, specifically cited by the 5DCA in Tallahassee.
Wouldn't you agree that perhaps the violation in Griffiths was equally, if not more, de minimis?
I mean, in that, the problem is that we're dealing with a warrant, and it's a search of a home. If we would love to go back on the case law of Griffiths, we would love to argue that.
In Griffiths,
but
there was a Cocoa police officer right there, present the whole time. He just didn't do anything.
He also wasn't named in the warrant, which was obviously the alternative, which was why that was not an alternative basis to reverse in that case. They stated, you could have named this Cocoa Beach officer. You did not. We don't know why you didn't. And we had no Brevard officers or deputies who were in the first, or I'm sorry, who were actually named in the warrant. I mean, of course, this isn't the time to be able to go back and overrule precedent of Griffiths, but it's our points that Judge Edwards had mentioned earlier, Price, Nunn, Wilson. There's also the case Allen, which was cited in Knight v. State, referring to this continuing jurisdiction, and basically saying that the tip, a confidential tip, was received within jurisdiction, but that did not constitute the commencement of the investigation until they began the investigation outside. And I think that's what carves us out of Griffiths, at least in this circumstance. And just to toss this in real quick, I know that my time is elapsing here.
I'll let Mr. Hyman go 2 minutes past, so go ahead.
Oh, I do appreciate it. No objections.
Doesn't matter if he objects, go ahead.
Talking about this being separate crimes, your breath, your BAL for taking a breath test versus, your faculties are impaired. It's the same crime. It's just two different methods of charging it. This was an investigation of a new crime because the actus reus of this crime is when they were in control of the vehicle. We are just finding out after
You
the
can't
fact.
charge him on unlawful blood alcohol level until you actually get it. So, I mean, you can use his blood alcohol to prove the DUI, but
Of course, but we're not going to charge that as two
I know.
separate offenses, Your Honor, so it wouldn't be a new crime in this case. I mean, we charge that as two separate offenses. We're going to eventually hear something about more than likely double jeopardy because it's that you're in control of this vehicle either while your faculties are impaired or while you have either the blood level or the breath alcohol level above. Those are just three alternative methods we have of charging this. And so this wasn't an investigation of a new crime. We're trying to figure out if there's an alternative method of charging him because we already know he drove, we know he looks intoxicated, and we've arrested him to take this further investigation. But if this court does not have any other questions, I'll rely on my briefs, and I ask that you reverse the trial court's order granting the motion to suppress.
all right, counsel, thank you. Interesting arguments from both sides. Well presented, thank you.
Thank you, Your Honor.